topics. Logic Blsllb Semester 1 2023. Wigmorian Analysis. Wigmorian analysis is a method of legal reasoning developed by John Henry Wigmore, an American jurist and legal scholar. This method is also known as charting the logical relationships of propositions, and it involves the use of diagrams or charts to visually represent the logical relationships among legal propositions in a legal argument. The Wigmorian analysis involves breaking down a legal argument into its constituent propositions and then charting the logical relationships between them. The goal of this method is to identify the strengths and weaknesses of the argument and to make it easier to communicate complex legal reasoning to others. The basic steps of Wigmorian analysis are: 1. Identify the main propositions in the legal argument. 2. Determine the logical relationships between the propositions, i.e. whether they are premises or conclusions, whether they support or contradict each other, etc. 3. Create a diagram or chart that visually represents the logical relationships among the propositions. 4. Analyze the diagram to identify the strengths and weaknesses of the argument. Overall, Wigmorian analysis can be a helpful tool for legal reasoning and argumentation, particularly in complex cases where there are multiple propositions that need to be considered and evaluated. Definition and law. Disablement refers to the loss of ability or earning capacity as a result of an injury, accident, or certain occupational diseases. The Workmen's Compensation Act, 1923 classifies disablement into two categories: partial and total disablement. Partial disablement, as defined in Section 2(1)(g) of the Act, refers to a situation where the disablement is of a temporary nature and reduces the earning capacity of an employee in the employment in which he was engaged at the time of the accident. In case of permanent disablement, it refers to a situation where the disablement reduces the earning capacity of the employee in every employment which he was capable of undertaking at that time. Examples of partial disablement include amputation through the shoulder joint, loss of fingers of one hand, loss of one eye, etc. Temporary disablement, as defined in Section 2(21) of the Act, refers to a condition resulting from employment injury that requires medical treatment and renders an employee temporarily incapable of doing the work which he was doing prior to or at the time of the injury. Overall, the concept of disablement is important in the context of labor law as it provides for the payment of compensation to workmen and their dependents in case of injury or accident resulting in disablement or death. The classification of disablement into partial and total disablement helps to determine the amount of compensation to be paid to the employee or his dependents. Industry is defined in Sec 2(j) of the Industrial Disputes Act, 1947 as any business, trade, undertaking, manufacture, or calling of employers, including any calling, service, employment, handicraft or industrial occupation or avocation of workmen. An industry exists when there is a relationship between employers and employees engaged in business, trade, undertaking, manufacture, or calling of employers, and the employees are engaged in the calling, service, employment, handicraft, industrial occupation, or avocation. Nuisance is an act or omission that interferes with the right of another to enjoy some property, causing damage or physical discomfort. It is an annoyance or harm that causes injury, danger, or offense to the sense of sight, smell, or hearing, or which may be dangerous to life or injurious to health or property. There are two kinds of nuisance: 1. Public or general or common nuisance. 2. Private nuisance or tort of nuisance. Public nuisance is an act or omission causing injury, damage, or annoyance to the public at large and people in general, affecting the public and being an annoyance to the people who come in contact with it. It is both a tort and a crime. Private nuisance is some unauthorized use of man's own property causing damage to the property, or some unauthorized interference with the property or proprietary right of another causing damage, but not amounting to trespass. Private nuisance includes obstruction to light and air, wrongful escape of foul gas or noise, water, filth, germs, etc. 1. Consent. Consent is a crucial element in contract law, and it means that both parties agree to the same thing in the same sense. For a valid contract, the consent must be free, i.e., not affected by coercion, undue influence, fraud, misrepresentation, or mistake. 2. Free consent. Free consent is necessary for the complete validity of a contract. When a party enters into an agreement without free consent, the agreement is void. Medical interventions also require the consent of the patient, which should be free, voluntary, and not affected by external factors. 3. Medical intervention. Medical intervention refers to any medicine, procedure, or device prescribed, administered, performed, or authorized by a physician. Patients have the right to refuse treatment, even if it is to their detriment. This right should not be misunderstood as an attempt to commit suicide or euthanasia. 4. Physician. A physician is an authorized practitioner of medicine who has graduated from a college of medicine and licensed by the appropriate board. The physician-patient relationship is a contractual relationship, and the physician agrees to treat the patient. However, the physician rarely promises a specific outcome or cure. 5. Terminally ill. A terminally ill person has an irreversible or incurable disease condition from which death is expected in the foreseeable future. The application of life-sustaining treatment would only prolong the process of dying. In such cases, medical ethics requires that the patient's autonomy and dignity be respected, and the patient should be provided with palliative care to alleviate their suffering. Analysis of argument. When analyzing an argument, it is important to consider its purpose, structure, language, and format. These factors can help you identify, interpret, evaluate, and construct arguments. 1. Purpose. The purpose of an argument is the goal or objective that the author is trying to achieve. This could be to persuade the audience, to inform them, or to entertain them. Understanding the purpose of an argument can help you determine whether it is effective or not. 2. Structure. The structure of an argument refers to how it is organized. This includes the order of the premises, the logical connections between them, and the conclusion. Understanding the structure of an argument can help you identify its strengths and weaknesses. 3. Language. The language of an argument refers to the words and phrases that are used to convey the message. This includes the tone, style, and rhetorical devices. Understanding the language of an argument can help you evaluate its effectiveness in persuading the audience. 4. Format. The format of an argument refers to how it is presented. This includes the medium, e.g., written, spoken, visual, the length, and the intended audience. Understanding the format of an argument can help you interpret its message and evaluate its effectiveness. Identifying, interpreting, evaluating, and constructing arguments. 1. Identifying. To identify an argument, look for the presence of premises. Statements that provide evidence or reasons, and a conclusion, the statement that follows from the premises. Arguments can be found in written, spoken, or visual texts. 2. Interpreting. To interpret an argument, try to understand the author's message and the reasoning behind it. Identify the premises and conclusion, and evaluate how well they support each other. 3. Evaluating. To evaluate an argument, consider its strengths and weaknesses. Look for logical fallacies, errors in reasoning, inconsistencies, and evidence to support the premises. Consider the context and audience, and evaluate the effectiveness of the argument in achieving its purpose. 4. Constructing. To construct an argument, identify your purpose and audience, and develop a clear and logical structure. Use evidence to support your premises, and consider the counterarguments and potential objections. Use language and rhetorical devices to effectively persuade your audience. In summary, analyzing an argument involves considering its purpose, structure, language, and format, and identifying, interpreting, evaluating, and constructing arguments requires a combination of critical thinking skills and knowledge of logical reasoning. Don't forget to like, share, and subscribe. Law_with_Janvi